A study of the unbreakable vow from a legal and ontological perspective. Abstract. This work analyzes the unbreakable vow as developed in the plot of the novel Harry Potter and the Half-Blood Prince from a legal and ontological perspective. In particular, the relationship between magic and law is investigated in light of social ontology and is compared to Roman law's obligations verbis contracti. Introduction. The world described in the Harry Potter series has an exceptional feature that distinguishes these works from many other excellent fantasy series. Instead of being located in some remote fictional world, locations such as Little Whinging, Diagon Alley, and Hogwarts all have quite familiar geographical locations, the county of Surrey, London, and the Scottish Highlands, respectively. Likewise, even the political geography of the novels should be quite familiar. Throughout the saga, we discover, for example, that there is a reserve of dragons in Romania and that Bulgaria and Ireland each have formidable national Quidditch teams. In other words, every magical community seems to be nothing more than a subgroup of citizens of a given nation. However, they are not like other citizens, for they are wizards and witches. In Rowling's books, we are made to understand that wizards and witches' magical abilities demand ad hoc legal measures such as the decree for the reasonable restriction of underage sorcery or the law regarding ownership of charmed objects. Furthermore, magic and law sometimes seem to merge to the point of generating fascinating magical legal institutions, such as contracts that are formed through the use of magical artifacts, such as the Goblet of Fire, or agreements that are concluded through the use of magic, such as the Unbreakable Vow. This work's main objective is to analyze one of these legal magical agreements from a legal and ontological perspective. To this end, this article first presents a brief exploration of the concepts of law and magic. 2. Thereafter, it compares an ancient legal institution and Rowling's Unbreakable Vow to show how in some cases, in the past, magic and law were considered the same thing. 3. This article then shows how magic and law do not differ significantly from an ontological point of view, rather, they are more distinct when considered from the perspective of social ontology. 4. 2. Law and magic. A law. In modern linguistic practices, the term law is often used even outside the legal context. Indeed, the word law can also be used, for example, in the scientific field to describe what always happens when the same conditions exist. However, there is a considerable semantic gap between, for instance, Newton's law of universal gravitation and the law that legalizes divorce in a country. While the former attempts to account for a physical phenomenon, the latter is the result of the will of a legislative body. Thus, it seems appropriate to distinguish between a legal sense and a scientific or magical, depending on the context, sense of the term law. In this regard, hereafter, it is proposed to ground such a distinction on the difference between what is possible and what is lawful one specifically. In a legal sense, a law distinguishes what is lawful from what is not lawful, while in a scientific or magical sense, a law distinguishes what is possible from what is not possible. From this perspective, a law such as Gamp's law of elemental transfiguration is to be considered law in a magical sense, since it dictates the rules of transfiguration and the exceptions thereto. Certainly, wizards and witches may attempt to break that law. However, as suggested in the novel Harry Potter and the Deathly Hallows, such an attempt would be destined to fail, as this law does not concern what is lawful but rather what is possible too. Then there are cases in the Harry Potter series in which the word law is to be understood exclusively in the legal sense. In this regard, consider, for instance, the previously mentioned law regarding ownership of charmed objects. That law does not determine whether objects can be enchanted, it is likely that all objects can be enchanted, instead, it determines what their owners can lawfully do with them. Finally, there are also cases where it is not easy to discern whether one is dealing with a legal institution or a magic spell. Consider, in this regard, the Unbreakable Vow. One might wonder whether it concerns the domain of what is lawful or that of which what is possible. An initial reading of Rowling's work could make one lean towards this second possibility. After all, the term unbreakable suggests that it is impossible to break the vow, not that it is unlawful to break it. On closer inspection, however, one can notice that it is indeed possible to break an unbreakable vow. Should this happen, there is an unpleasant consequence, the death of the one who breaks the vow. Nevertheless, it is possible to break an unbreakable vow. What is not possible, however, is the conjunction of breaking a vow and staying alive. Therefore, when the literary character of Ronald Weasley says, "Well, you can't break an unbreakable vow," he does not mean that it is impossible to break it but simply that someone cannot break a vow and remain alive. Thus, exactly like laws in the legal sense, even an unbreakable vow does not make a particular action impossible. What changes is how a breach is detected, and sanction is provided. In the case of an unbreakable vow, the punishment that occurs for a breach, the death of the one who broke the vow, occurs automatically and without any human mediation. In short, it occurs magically. B. Magic. In the previous subsection, it was suggested that the unbreakable vow does not appear to concern the domain of what is possible, and is to be considered magical only to the extent that breach discovery and the infliction of the corresponding punishment occur automatically and do not require any human intervention. These statements, however, are not immune to criticism. An initial criticism might be that simple impossibility is too restrictive, covers too few cases, whereas conjunctive impossibility is too permissive, covers too many. Point 15. Thus, an intermediate criterion, one that, while admitting that the certainty of death does not make it impossible to violate a vow, acknowledges that it affects people's choice to violate the vow seems necessary. It could also be argued that proving that the unbreakable vow does not seem to concern the domain of what is possible does not imply that it concerns the domain of what is lawful. Indeed, we have no information concerning the lawfulness or unlawfulness of such a vow. Certainly, it may be that the subject matter of a vow may be unlawful and that, for example, someone commits themselves to kill another person with the unbreakable vows. However, even in such kind of cases, it is the subject of the vow that should be considered unlawful and not the vow itself. Finally, one can also criticize the supposedly magical nature of the unbreakable vows. Indeed, if the unbreakable vow's magic lies in the automatism of its effects in case of vow violation, it can be argued that it is not very different from some Muggle technologies. In this regard, it is sufficient to consider the wide range of contemporary technologies that can perform automatic actions according to certain inputs. Indeed, a careful reading of Rowling's novels would lead one to affirm that magic is considered a kind of technology for the magical community and that technology is considered a kind of magic for the Muggle community. After all, as members of the Muggle community, we use the increasingly complex technology that is at our disposal without really knowing how and why it works. When it breaks down, we call in an expert to repair it, or we throw it away. In our trust that, ultimately, technology will always work for us, we are like the people of ancient times who relied on magic that seemed to work for them and had worked for their ancestors for a very long time. In other words, as Derrida correctly noted, because one increasingly uses artifacts and prostheses of which one is totally ignorant, in a growing disproportion between knowledge and know-how, the space of such technical experience tends to become more animistic, magical, mystical. Therefore, the magical characteristics shared by both the magic of wizards and witches and Muggle artifacts, including the law, would lie not so much in the automatic nature of their effects but rather in the user's lack of knowledge of their functioning. 3 legal forms and magic formulas. A. The unbreakable vow in its form. Even though it seems not possible to determine the lawfulness or unlawfulness of the unbreakable vow, at first glance, it appears to share some features with Muggles' legal obligations. Indeed, both the unbreakable vow and Muggles' legal obligations involve a tie between at least 2 parties that imposes duties on one party in favor of the other. 21. In the 3rd chapter of Harry Potter and the Half-Blood Prince, it is possible to observe the formation of an unbreakable vow. That chapter tells of the visit Narcissa Malfoy, mother of the main character's rival, and her sister Bellatrix Lestrange made to Severus Snape. Narcissa wanted Snape to help her protect her son Draco, who has been assigned a risky mission by Lord Voldemort, the main villain of the Harry Potter series. Snape, the Hogwarts School potions professor and director of Slytherin, the Hogwarts house of which Draco is a member, offers to help Draco. However, Narcissa is not content with a mere offer of help, she asks him to make an unbreakable vow. It is at this point in the narrative that readers learn that, although it may seem to be an agreement between 2 parties, the formation of an unbreakable vow also requires a third party, the bonder. 22. The latter seems to be an exciting role to study since it appears to be, in a way, entirely external to the vow. The bonders does not make any promises or require that they be made. However, it seems to be the only party entitled to use magic during the stipulation of an unbreakable vow. The bonders, indeed, seems to be exactly what the name indicates, the personification of the bond created by the vow. Once a bonder is identified, the novel suggests that the unbreakable vow's form requires the contracting parties to hold hands throughout the vow process. To the eyes of a Muggle jurist, such a handshake might seem like a merely symbolic act similar to those used by Muggles in some of their legal obligations. However, since the unbreakable vow is stipulated through magic, it is impossible to know whether such a handshake is necessary for the bond's magical element to take effect. 2. Therefore, once the contracting parties' hands are joined, they proceed to make the vow through a question and answer form. Specifically, in the case mentioned in the 6th novel of the Harry Potter series, Mrs. Malfoy asked Snape the following 3 questions. 1. Will you, Severus, watch over my son, Draco, as he attempts to fulfill the Dark Lord's wishes, W2. And will you, to the best of your ability, protect him from harm, S3. And, should it prove necessary, if it seems Draco will fail, will you carry out the deed that the Dark Lord has ordered Draco to perform? 24. Interestingly, the Hogwarts professor's answer for each question is a simple and assertive I will. Given the 3-question formulation of the vow, one might wonder whether those 3 conjunct promises are part of a single unbreakable vows or whether they are 3 different unbreakable vows. In support of the first option, it is possible to note how the 2nd and 3rd questions are preceded by the conjunction and. In contrast, in favor of the view that these are 3 distinct unbreakable vows, one could note that the bonder's magical activity occurs after every single question and answer. Whatever the case may be, the consequences of any violation of the unbreakable vow, S.E. would not change. If it were a single vow comprised of 3 conjunct promises, the breach of one of them would violate the entire vow and result in the death of the party who breached it. In contrast, if each promise corresponds to a single unbreakable vow, the breach of one would violate the corresponding vow and, again, result in the death of the party who breached it. More interesting than the number of vows is the person for whose benefit they were made. Indeed, in the vow under consideration, none of the promises favor the involved parties. Instead, each promise is for the benefit of a person who was not even present during the vow stipulation, i.e., Draco Malfoy. The very idea that an unbreakable vow can be made for a non-contracting party's benefit involves several considerations. Among these, the most important concerns what would happen should the person for whose benefit the vow was made be unaware of it or, worse, opposed to the subject matter of the vow. Based solely on what we know from the books, one could venture that the non-contracting parties will, or their knowledge of the vow, is irrelevant. However, it is worth noting that the cooperation of the person for whose benefit the unbreakable vow was made could facilitate the fulfillment of the vow. Fulfilling an unbreakable vow, in fact, does not seem to be particularly easy given the wide semantic range of the terms used in promises. Consider, for example, the terms watch over used in the first question of the analyzed vow. What would Snape have been required to do to fulfill this requirement? Would it have been sufficient to occasionally check in on what Draco was doing? Or should he have been watching over Draco for every moment of the latter's life? The problem posed by the nature of the vow is thus purely definitional in nature, who defines the semantic breadth of the terms used in the unbreakable vow questions, and when they do so. The books provide no answers to these questions. However, it is possible to imagine that the criteria for the semantic interpretation of an unbreakable vow are, explicitly or implicitly, defined by someone simultaneously to the promises, as, otherwise, one would commit to something undefined. B. The form mirrored by Roman law. Legal obligations differ from other types of intersubjective relationships because the creditor, also called the active subjecto in Roman law, can only satisfy their interest through the debtors, also called the passive subject in Roman law, cooperation. Legal obligations, in other words, demand that the debtor must behave in a certain way should they not want to be held liable against the creditor. 2. In the previous subsection, it was argued that although it is impossible to determine whether an unbreakable vow is a legal obligation, both legal obligations and unbreakable vow seems to share some features. 2. In particular, the unbreakable vow's oral form and its ritual nature seem to recall an ancient obligations rebus contracti of Roman law. The sponsio 7. The sponsio is an ancient legal obligation whose origin probably dates back to the dawn of Rome. A historical period, that of archaic Rome, in which IWS, i.e., what was legal, and fos, i.e., what was sacred, were indistinguishable. It is precisely this lack of difference between what was sacred and what was legal that makes certain Roman legal institutions so intriguing. In particular, it has been argued that it was likely the religious dimension that made the specie both extremely formal and extremely binding in intersubjective relations among Roman citizens. Point 28. It seems, therefore, that the sponsio required the presence of at least three parties, the use of a question and answer form between two parties, the involvement of a third party called a pontigex, a sort of cleric/jurist, who would have pronounced the ritual legal/religious formulas, which the parties would then repeat, and the congruentia verbora, which means that the verbs used in questions, spodes, had to be used in the responses to those questions, spondio. Furthermore, it should also be noted that the sponsio was a prerogative of Roman citizens. In other words, the sponsio could only take place between Roman citizens and only in Latin, otherwise, it would have been devoid of any legal force. Point 2. Even from this brief examination of the sponsio, it is possible to note certain similarities between this legal obligation and the unbreakable vow. The first similarity concerns the number of parties involved. Both the vow and the sponsio require the presence of at least three parties. However, the non-contracting parties, namely the bonder and the pontigex, play different roles. In the case of the unbreakable vow, the bondero takes action, using magic, following each individual vow. In the case of the sponsio, the pontifex takes, legal and religious, action before every single promise. Another similarity concerns the question and answer form that both the sponsio and the unbreakable vow require. However, even in this case, a subtle difference must be noted. While the sponsio requires perfect correspondence between the verb s used in the question and the verb used in the response, it is not clear whether this requirement is also necessary for the unbreakable vow or whether the repetition seen in the previously presented example is instead a lucky coincidence largely due to the syntax of the English language. Furthermore, it should also be emphasized that both the sponsio and the unbreakable vow are reserved for specific groups of individuals, the citizens of ancient Rome in the case of the former and citizens endowed with magical powers in the case of the latter. However, although there is no doubt that the verb spondere could be validly used only by Roman citizens, there are doubts as to whether only wizards and witches can make an unbreakable vow. In particular, since the magical element of an unbreakable vow is provided by the bonder, one might wonder whether other parties must be wizards or witches. Finally, there is also the magic that permeates and characterizes both the unbreakable vow and the sponsio. However, while there is no doubt concerning the unbreakable vow's magical element, it may be difficult to identify the magical element of a legal obligation. For this reason, the next subsection discusses the magical aspect of Roman law and, in particular, the reasons why the sponsio should be considered both a legal obligation and a magical act. See the magical aspect of Roman law. The comparison between the unbreakable vow and the sponsio only shows a certain degree of similarity between a fictional magic spell and an ancient religious/legal ritual. However, the assumption that magic and law are in some way similar has not yet been proven, and religion and magic indeed seem to be quite distinct. In the Harry Potter series, for example, it seems that magic and religion are different and coexisting spheres. However, the same cannot be said for the early Roman Civitas, in which magic and religion were considered the same. As reported by Farrelly, according to Swedish philosopher Axel Hagerstrom, the gods of ancient Rome were magical forces personified in beings apparently endowed with will. The gods' benevolence depended on neither humility nor love manifested in the act of worship but was magically prompted by the act of worship itself. 31 In ancient Rome, citizens' inner attitudes towards the gods were completely irrelevant. What mattered was the exact recitation of certain words or the exact performance of certain actions. In this sense, acts of worship were magical acts. Thus, considering that at least in the early phase of the Roman Empire, it was not possible to distinguish between acts of worship and legal acts, it can be concluded that legal acts were also magical acts. M2. Therefore, even a religious/legal act such as sponsio, which consisted of the performance of symbolic acts and the pronunciation of verba solemnia, must be considered a magical act. In particular, Hagerstrom considered the sponsio a legal/magical act suitable for establishing a certain power over a person. The formality of this act was understood not as a legal validity condition of the act but as a creative force of specific automatic effects. Indeed, the violation of the ancient Roman community's legal and religious norms, as well as the violation of a sacred/legal oath such as the sponsio, automatically constituted a violation of the pax deor, much like how breaking the unbreakable vow entails an automatic punishment. Therefore, not only did the sponsio automatically create effects, but its violation also produced automatic effects that did not require human intervention. Of course, it could be argued that the restoration of the pax deora would have required the discovery of a violation and the imposition of sanctions. However, the violation of the pax deon occurred automatically, regardless of whether the Roman Civitas was aware of it. For this reason, it is possible to consider the violation of the pax deor so as an automatic punishment that did not require any human intervention. Moreover, it should be noted how the idea of the magical origins of Roman law proposed by Hagerstrom is still much debated. Some authors, in this regard, have accused the Swedish philosopher of having overestimated the magical element in ancient Roman law. Indeed, although Roman law scholars generally recognize a particular affinity between legal formalism and magic/religious formalism, this would not allow claiming that law and magic were the same in ancient Rome. Not to mention the fact that tracing the origins of Roman law and, consequently, the origins of most of today's legal systems back to a sort of religious superstition would deprive the law of objectivity. However, as pointed out by Hagerstrom himself, the goal of his study is not to show that law and magic were one and the same in ancient Rome but, rather, to demonstrate that ancient Roman citizens considered the law a form of magic. 34. Muggle's ontology and magic words. A Muggle's ontology. In the Harry Potter series, magic acts in the field of what is possible. This means that magic makes certain things, like enchanting people or transfiguring objects, possible. However, outside of literary fiction, not many people would be willing to argue that things such as curses, spells, or magical potions exist in the ordinary world, i.e., the Muggle world. On the contrary, if one wished to draw up a catalogue containing everything that exists in the world, they would likely not include things like magic wands, flying broomsticks, or defensive spells in it. 3 Instead, a serious universal catalogue of our world would likely be composed of the entirety of the people who inhabit the world and the objects to be found in it, as well as everything that happens to these people and objects. Some people are probably convinced that nothing magical happens in the world. Many persons, instead, are certain of the existence of things such as money or phenomena such as weddings. However, from a strictly realistic point of view, money and weddings, as well as magic, do not exist in our world. Consider, for example, money. In the world, there are a great number of small pieces of colored paper that many of us keep inside our wallets, but there is no such thing as money. If money exists, it exists only because we have assigned the status of money to certain objects. In other words, no pieces of paper perform the function of money because they are printed in a certain way, have a specific size, or feature a particular color. A piece of paper performs the function of money only due to the collective acceptance that it has the status of money in a specific context, usually a state or group of states. From the point of view of social ontology, the law does not seem very different from money. Indeed, the law as well as money would not exist if there were no beliefs, perceptions, memories, desires, will, intentions, feelings, and actions related to it. In other words, their existence depends on our intentionality. The latter is a basic, although amazing, aspect of our mental life. It is the power of minds to be about, to represent, or to stand for, things, properties and states of affairs. So thus, one might venture the hypothesis that it is precisely collective intentionality and collective acceptance that make laws in our world concretely effective. In other words, unlike in archaic Roman times in which belief in the magical/religious effects of legal entities led people to believe in the existence of laws, today the concrete effects of legal institutions seem to be linked to the collective acceptance of, and collective intentionality on, the law. One in this regard, consider, for example, the legal institution of marriage. Laws belonging to different contexts, religious or civil, prescribe different procedures through which two people can marry. In some contexts, for example, two people can get married only after performing certain gestures and pronouncing certain formulas in front of a group of people too. However, if certain gestures and formulas were not recognized and collectively accepted as constitutive of a marriage, there would not be any kind of marriage. It would perhaps be possible for people to fall in love and spend their lives together in the same place, but it would not be possible to do so as husband and wife. Indeed, terms such as husband and wife denote a status that people acquire as a result of a specific legal event. The marriage point. However, a person cannot become a husband or wife simply because they have performed specific actions. Such statuses can be acquired only because some activities are recognized as being suited to constituting a marriage in a given context. Legal entities such as marriages, contracts, or public limited companies cannot be reduced to, and should not be confused with, physical entities. Of course, they can be constituted by physical entities, but they cannot be reduced to them. Thus, it seems not possible to reduce a verbal obligation to either a series of sounds or to the feeling of being obligated, as well as it seems not possible to reduce a $10 banknote to a mere piece of paper. Unlike entities such as animals or trees, which exist regardless of the intentionality of subjects towards them, things such as money or oral agreements seem to ontologically depend on our beliefs. Therefore, from the perspective of social ontology, there is a significant difference between magic and law, which is well emphasized by the unbreakable vow. Indeed, as repeatedly noted, what makes the unbreakable vow magical is its ability to automatically detect and punish any breach of its term without the need for human mediation. In comparison, Muggles' legal obligations seem to produce effects in the ordinary world only through human mediation, and only as long as there is collective acceptance of the existence of such obligations. In other words, it is humans who make legal institutions concrete. They are the ones who find, judge, and punish any breaches of obligations. Unlike the Roman Empire period, indeed, contemporary Muggle legal obligations lack any automatic self-fulfilling element. The magic words. From an ontological perspective, both magic and law do not exist. There are no things like legal obligations, laws, spells, or curses in our world. Point 4. However, from the point of view of social ontology, which focuses on study of the nature and properties of the social world, it is possible to explain certain legal phenomena, such as legal obligations or marriages, with reference to the notion of collective acceptance. Such acceptance involves believing that the entities have that status as well as being disposed to treat them as such. In other words, laws, contracts, legal obligations, or marriage produce concrete effects in the world because we believe they have a certain status. According to a social ontology perspective, legal obligations produce concrete effects in our world if and only if some individuals recognize, and collectively accept, their legal status. The same considerations seem to be true even for the unbreakable vow. Indeed, since it requires that more than one person take part in its creation, there seems to be a minimal form of collective acceptance. In other words, all parties to the unbreakable vow seem to have to collectively accept the vow itself, otherwise, they would not take part in the spell. However, it is important to note that the unbreakable vow seems to be an exception to the normal functioning of magic in Harry Potter's world. Indeed, in the world created by J.K. Rowling, most spells produce effects regardless of the collective acceptance of their status and effects. For example, if a wizard or a witch waves their wand and utters the word lumos in Harry Potter's world, a light will be produced regardless of whether anyone knows that spell has been cast too. In other words, in most of the spells of Harry Potter's world, what matters seem to be the individual intentionality and magical abilities of the one casting the spell. Point 53. Of course, one could argue that words are as important in Harry Potter's magic world as they are in Muggles' legal matters. Indeed, just as in the wizarding world, a wizard or witch only needs to utter the word illumos to create light, two people in our world only need to utter the words I Dao in a certain context, with witnesses, celebrants, etc., to become spouses. However, from an ontological point of view, while it seems that spells in Harry Potter's world generally require only the intentionality of those who utter them, individual intentionality, the legal effects of an act exist in our world to the extent that it is collectively accepted as a legal act. In other words, certain formulas and rituals are considered legal because they are collectively recognized as having a legal status. At this point, it could be argued that even if the right words were to be pronounced in the correct context, the effects of a legal obligation would not actually exist in the real world but rather in the minds of individuals who would consider them as real and act in the world accordingly. However, in the words of Professor Dumbledore, headmaster of Hogwarts and one of the wisest and most powerful wizards of the Harry Potter series. Even if such legal effects were only existing in people's heads, why on earth should that mean that they are not real? 36b Conclusion. Arguably, a legal analysis of the unbreakable vow does not provide any certainty as to whether or not it is a legal obligation. Nevertheless, studying such a fictional enchantment/institution allows us to examine legal obligations from an often ignored perspective, one that makes it possible to clearly distinguish the boundaries between magic and law, the perspective of law and litera. Specifically, this paper has attempted to show how, although seemingly distinct, magic and law have some similarities, which seem to connect them. Therefore, after showing how in ancient societies, as ancient Rome, legal acts were considered both magical and religious, it has been pointed out that some similarities between law and magic seem to persist to this day. Particularly, there seems to be at least one element in common among the unbreakable vow, the sponsio, and contemporary conceptions of legal obligations, the belief in being bound. Indeed, both the Snape and Malfoy characters for the unbreakable vow and ancient Roman citizens for the sponsio and those who enter into a legal obligation nowadays believe to be bound in some way. The belief is the same, what changes are the reasons why they believe to be bound.